Yes.
Item 27.
27. Yes.
Lordship, this is regarding dismissal for
Yes, dismissal of service.
Lordship.
Petitioner.
Lordship, I have to.
Yes.
Lordship, I am praying if this matter can be fixed on.
On what ground you have been dismissed from service?
Lordship, there was a departmental inquiry, Lordship.
What is the charge against you?
Lordship, against the charges are that, Lordship, I was appointed as the warden, Lordship, and there was an incident of jailbreak in the jail, Lordship, district jail. That is the case, Lordship, and I was also one of the member at that point of time, Lordship.
So you are responsible. He is the warden.
And there is no charges against me, Lordship. That is our case, Lordship. Charges has not been framed, Lordship.
Who has passed this order? Did you prefer an appeal?
Yes, my lord. Appeal disposed.
Prefer an appeal.
Yes, Lordship.
Appeal was also rejected.
Lordship, after
Yes, Lordship.
it has been reverted back to this red court, Lordship.
No. Original authority passed an order. Disciplinary authority passed an order against which you preferred an appeal.
Lordship.
In terms of the rules.
Yes.
Appellate authority has confirmed the original order.
Lordship. But there was no finding, Lordship.
No?
No finding with regards
Finding
to the
of what?
with regards to the charges, Lordship. Under what I have been. There is no clear finding, Lordship, as regards to the article of charges, Lordship.
How many persons have escaped from the jail? 20 or 25? 23. Did you secure them?
Yes. And he has retired from service in the meantime.
The question of retirement and service matter doesn't arise. If he succeeds, you will have to pay him the money.
He has already been dismissed, but they want to get a service credit. So they are challenging the departmental process.
Sir, in service matter, there is no question of infructuous unless you grant a relief. If you court satisfied the order,
Yes, then
even without work, he will be entitled to all the benefit.
all the benefits. Right.
It's a bonus.
That is why they are challenging the entire
So
department.
what are the charges against him?
If Lordship comes to page 50, Lordship,
Page number
50,
50.
Lordship. That is the inquiry report against me, Lordship. It does not contain any article of charges, anything, Lordship. No statement of interest,
One minute,
anything.
sir. Yes. So what is the findings, sir?
Sir, senior counsel is on the line. She is.
This is the finding of the inquiry officer.
Lordship can have it, we can have, because there was it had a checkered history. This case had a checkered history and long run of
Mr.
litigation.
Khan is different.
Lordship.
Whether he has got a past record or good record and all, we are not
Lordship is correct.
to see the extenuating or aggravating circumstances. But
Lordship
you
is correct.
only from the records, the documents inspected, studied and the statement deposed by the prosecution witness, charge sheeted official did not exert utmost vigilance to prevent the escape of prisoners is true and correct and proved beyond reasonable doubt.
Lordship, this is an inquiry report, detailed inquiry report, Lordship. We have given the copy to the court also. This is a detailed inquiry.
This is the finding of the inquiry officer. What kind of finding is this?
Lordship is
How
correct.
are you going to sustain it?
Lordship will have to go through the detail of the...
This is the order, this is the finding. Where is the order of the dismissal authority?
Lordship, there is a detailed inquiry being conducted. We have submitted to the court. Lordship can have it on 19. We'll explain the
Correct,
court in
sir,
detail.
Mr. Khan. You have conducted detailed inquiry. The inquiry officer has not rendered a correct finding.
Lordship
This
is
is not
correct.
a finding. Shall I say that the repetition is allowed? Is it suffice?
No.
Or
Lordship is
repetition
correct.
dismissed?
No, there has to be a speaking order. Lordship
Yes.
is correct.
Should be a speaking order. It's a very bold order, like your head and my head.
Lordship.
Yes. Post on 4th.
Lordship, I'm praying it, but I can be taken on a fifth.
No. It's a very simple case. Finish it.
Lordship. Hello.
Very simple case. See, you read Karnataka case, ECIL case. The matter will have to go back to the disciplinary authority or the appellate authority, depending upon what you are going to argue.
Lordship.
Disciplinary authority. From there, proceeding will have to commence. Matter will have to go, and the inquiry officer will have to render a reason finding.
Lordship.
Hello.
Item 28.
28.
Yes.
May I please, Your Lordship? This is also a case of dismissal, Your Lordship, from service.
Dismissal of service.
Service. In fact, earlier order, both the parties considered to be on 12th of March, but it seems Lordship has fixed several cases on 12th March.
Is it a nationalized bank?
National, Meghalaya Rural Bank.
Nationalized bank.
Yes, Rural Bank. Yes.
Rural bank. How is it amenable to the jurisdiction of this court?
Yes, my lord.
Is it amenable to the jurisdiction of the court? Bank.
Yes, yes, Bank. Bank Council, I don't know, today is absent, it seems.
No, sir, that is right. You said Meghalaya Rural Bank.
Rural Bank.
How do you say it is coming within Article 12 of the Constitution of India? How do you say that it's a state?
State, yes, it will be.
You are for the
I am the petitioner.
petition. That's why we are asking you a question. I'm asking you a question. What is the charge against them?
The charge for disbursement of loan, loan to farmers, 167
It has
farmers.
become sticky.
Yes.
They are not able to recover it.
No, disbursed, but there is a misappropriation, the allegation is done.
Misappropriation by the official.
In fact, I have the allegations against me with the headman and some other ladies who took their guarantee. There are a lot
Any
of
inquiry was conducted?
conducted. Inquiry conducted means what happened, the moment I give a show cause, then those locona, they again fill up, again they ask me again statement of allegation. Again, I have to give, in that manner, I think I am challenging about 12, 11 orders. And inquiry, there are 2 inquiry reports, Your Lordship. I have to give 4 times written statement of defense, Your Lordship. When I point out the locona, they again give corrected show cause.
What's your designation, sir? What's your designation?
As a branch manager.
Branch manager. No representation for the bank. What's the matter on 4th,
Photo, yes.
Monday?
As you Much of that.
I think
Just give the list of, just
Yes.
list of events, and just not more than 4 pages.
Ajal.
And also refer to the page numbers, but correspondingly we can refer to that also.
Ajal.
Ask your junior advocate on record to do that.
Yes.
item 29.
May I please, Lordship? My Lord, this is a discharge on the medical ground, my Lord. On medical ground.
Medical?
Medical ground. Medical invalidation, my Lord.
Medical invalidation.
My Lord.
Yes.
At 29 and 30, my Lord. My Lord, this is the second round of litigation, my Lord. On the first round of litigation, my Lord, the respondent authority has cancelled the order, and without convening any fresh court of inquiry, any fresh medical board, they have issued the impugned order.
Once again, they issued the
On
very
the
same order.
second.
Very same order.
My Lord, I require
Giving very same reasons.
no reason.
Different reasons.
My Lord.
What is medical reason, medical grounds?
It's they say that it's ADS, alcohol dependency syndrome.
What is the nature of work?
My Lord, it's he's a combatant, my Lord, Havaldar.
A soldier, my lord.
He's a soldier, true soldier.
Peter Bottle, Peter Carey.
My Lord.
So when he consumes alcohol, he is fit to do the work.
It's it's
But what happens, they call it alcohol dependence syndrome, my lord. When they reach a certain level of alcoholism, my lord, which affects
When you withdraw it, then you have the problem.
my lord. He reached that stage, my lord.
Then don't withdraw it, give him. Yes,
I'm praying that it can be,
Tuesday, 5th.
my Lord, can it be on 12th?
So 2018 matter, we don't want to give a longer date. Get ready with the matter.
12th.
5th. Yes.
29 and 30 is same.
30 also identical matter. Next item is also identical, my lord. Same
Yes.
discharge
Both
of
the matters.
syndrome.
Here also same, alcohol syndrome.
My lord.
Item 31.
May it please, Lordship.
Ajit Paul.
Lordship, this matter, Lordship, it's dismissal from service, Lordship.
1 minute, 1 minute. Not, which item, madam?
31.
Item 31, my Lord.
31. Oh, yes. This is also removed from service.
Removal from service, Lordship.
For
Lordship,
Lordship, here the petitioner is a temporary appointee, Lordship. Lordship, right? And as Lordship, he was
I was
relieved
appointed
from his
on-
services, Lordship. In the year 2019, Lordship, he was relieved from his services. He was appointed on a temporary basis, Lordship. So challenging that, they have come before this honorable court.
how many years you have been working?
He was
More than
working
7
for
years, Lordship.
seven plus years.
7 years.
Lordship.
Lordship, if you kindly have the last order, Lordship, the learned single bench has permitted us to file an additional affidavit to bring on record certain documents, Lordship, which we have obtained through RTI.
File it and get ready in the matter, the next hearing.
Lordship, therefore, I'm praying for 18, Lordship. 18.
Why such a long date, sir? You're asking for 3 weeks.
Because these documents, Lordship, we need to obtain through RTI, Lordship, and the process
is pending from 2020. Now you are going to ask.
Lordship, because during the course of the hearing, there seemed some confusion, Lordship, and then we need to seek some instructions. Therefore, we have filed the RTI, Lordship. And these documents have been obtained, Lordship, but unfortunately, the petitioner here couldn't hand those documents to us, Lordship, but it is expected to be handed over to us this week, Lordship. Therefore, I'm praying for 18, Lordship, if subject to your Lordship convenience. In the meantime, we'll file our affidavit, Lordship.
How do you say that the person is a part-time lecturer or teacher?
Lordship, there is no appointment, no selection process, Lordship.
Page number 25, 27, annexure 2,
Lordship.
you are given a certificate.
Lordship, this case actually, Lordship,
Full-time lecturer.
I was appointed as a teacher for the course of computer application, Lordship. Later, Lordship, on 2019, they came up with a resolution that this course is it's not necessary anymore, and they have introduced a new course, Lordship. And with that aspect, Lordship, we are seeking this information through RTI to see the syllabus of this course, Lordship. And it turned out, Lordship, this the same syllabus is
Sir, she is a permanent full-time teacher, sir.
No, Lordship, there is no procedure of selection, Lordship. No procedure was followed, Lordship, during his selection.
In appointment.
Lordship, he was appointed purely on temporary basis, Lordship, with the consulate.
But what is it, page number 25? 27, sorry.
27, Lordship.
full-time lecturer. What has happened, Lordship, they have replaced this course with another course, Lordship, just giving it a different name. And they have replaced this course, Lordship, computer science, with a different name. And it seems like the same syllabus is followed, Lordship, even in that course, Lordship. So we're obtaining these instructions through RTI, Lordship.
Full-time lecturer,
Lordship,
Lordship,
just to terminate me,
he was working as a full-time, but Lordship, on temporary basis, Lordship. That doesn't mean that he was appointed on as a permanent appointee, Lordship, in the college.
Where is the appointment order given to him?
There is no appointment, Lordship.
Then why did he give the certificate like this? He should have given certificate that is a part-time lecturer, serving as a full-time lecturer.
Lordship.
He should have given like that.
the only ground for...
And you've been asking her to take classes, lectures, etc. to the other staff.
For which, Lordship, we have adequately paid the remuneration, Lordship. In fact, he was paid at par with the other teachers, Lordship. That is his main contention, Lordship, before this honorable court.
How do you recruit?
Lordship, we follow the Assam aided college rules, Lordship, for appointment, Lordship. which has been adopted by the state of Meghalaya, Lordship.
Any person have been appointed after disengaging us from the services?
No, Lordship.
Nobody has been appointed.
No, Lordship.
So no computer classes at all.
Lordship, in what has happened in
This is a matter is of the year 2015. She has been appointed in the year 2015. Case is of the year 2020.
Lordship.
After 2020, you have not engaged anybody.
No, Lordship.
So you have engaged no temporary
There is no
teacher.
department, Lordship. There is no computer department, Lordship. That is what is our case, Lordship. But they are projecting the case that there exists a department, computer department, and he wishes to be.
But do you mean to say that the letters identity card given are all fake?
Lordship, at that relevant point of time, the college and the higher secondary section was together, Lordship. But in the year 2019, Lordship, due to bifurcation, Lordship, it was separated. The management and everything got separated, and he was given an opportunity to take the job at the higher secondary level on completely different basis. But he did not agree to that, Lordship. And thereafter, Lordship, this
Lordship,
petition was filed.
The department is still persisting, Lordship. Just that they have given a different termination.
In fact, Lordship, on the last occasion, one hearing was taken up, Lordship. The NIHU has clarified their stance that there do not exist any department.
Sorry, your action is completely illegal. Based on the documents here, he's a full-time lecturer. You can't say he's a part-time lecturer. Then you make them as pastime. That's how it's going on. Not correct. You get on the matter next week.
Lordship, on 18, Lordship will file the affidavit in the meantime, Lordship.
Yes. Post on 12th.
Lordship, 12, I have some difficulty, Lordship. If Lordship permits on 18, Lordship. 18.
18th.
Deeply obliged, Lordship.
I
We'll
think
file our affidavit in the meantime, Lordship.
You must see, when the court is in your favor, you must try to grab the opportunity. That's all I can tell you.
Deeply obliged.
Beyond that, I can't say that.
Deeply obliged.
Today I'm in your favor, tomorrow I don't know. Yes. Yes.
Apply.
item 32.
Lordship, in this case, I am appearing for the petitioner, Lordship.
Yes, sir.
Lordship, may I pray this matter may be taken up on the 5th day of March, Lordship.
21, sir?
On the 5th day of March, Lordship.
6th of March.
5, Lordship.
Oh, no, 6th of March.
5 of March.
5th of March.
5th of March.
5th of March, yes. The request. 5th of March.
Item 33.
Please reject. Receive this matter related to retirement benefit, Your Lordship.
Retirement benefits.
Yes, sir.
When did you retire?
On
2010.
When? 14 years of gone.
2010.
2010.
There was a DP initiated against him post his retirement. And his gratuity was withheld on account of certain misappropriations that came to light after his retirement.
Misappropriation case.
Lordship.
Have you conducted inquiry
Lordship.
and dismissed him from service?
Not dismissed him from service. They've asked for withholding his gratuity, to forfeit the gratuity amount which was due to him post-retirement.
But how can you do it without conducting an inquiry?
No, inquiry was conducted.
Huh.
Inquiry was conducted. They have only challenged the show cause notice of inquiry.
Charges have been proved.
Lordship.
And that you withheld gratuity.
Lordship. Now what's happened is that in his prayer, they have only challenged the show
Which
cause
in terms
notice.
of payment of 4(6) of the Payment of Gratuity Act or your rules?
No, the statutory rules.
Statutory rules.
So in the prayer, what he's challenged is the show cause notice. Only. After participating, Lordship. So
Only
he received
show
the
cause
show cause notice, he participated in the departmental proceedings.
Where is the notice?
At page, no, the prayer is at page 10.
Page
Can
10.
you have the prayer?
Page 10.
Page 10.
Page 10 means volume 2. Huh?
Page 10 of the writ petition.
So this is, Manoj, the second round of litigation.
1 minute, sir. Set aside and quash the order dated 11/5/2011 and 22/5/2014.
Lordship. Now, just see, can you see 11/5/2011 was the first order which was passed by the corporation, making certain adjustments to his leave encashment and gratuity without resorting to a departmental proceeding. Now, challenging that, they were before this honorable court by way of a writ petition, and that was set aside.
Oh, 11/5 was
Set aside. But I think inadvertently they challenged the same order again in this writ petition.
Oh.
Thereafter, with the leave of the court, another DP was initiated and a show cause notice was issued on 22/5/2014, which is at page 24.
24. 24.
24.
Yes.
So this is the order dated 22/5/2014 asking him to furnish an explanation. So only this is under challenge. He participated in the inquiry. He responded to his charges. My lords, he participated. Now, after participating, and this is culminated in a final inquiry report, he is challenging only this show cause notice. Now, this issue was brought to the notice of this court on the last hearing last year, and they filed a miscellaneous application for amending the prayer. But in the course of the hearing, I'm not really sure why they withdrew that application. So there is no challenge to the final inquiry report as well, only the show cause notice.
Yes, Your Lordship. Before we go to that, Your Lordship, I would like to clarify from my friend, Your Lordship, because by the order dated 10 August, Your Lordship, 2023, he has submitted that to work out a settlement, Your Lordship. So, in order...
How are you entitled to the terminal benefits, sir, when you are not challenged the final orders? The final order is withholding of gratuity to a tune of about 10 lakhs, etc. Is it not? What is the amount of gratuity you are entitled to?
11 lakhs, Your Lordship. Or 7 lakhs, Your Lordship.
So whatever it is. But you have not challenged the final order. And according to your friend, you have filed a petition for amending the prayer that has been withdrawn. What is otherwise? Nothing otherwise.
Yes, Your Lordship. I have to seek instruction, Your Lordship. I have
No instructions at all.
But you have
Slowly going. At least today I say I was informing the bar. At least I'll dispose one case today. Now I'll dispose this case. That's all.
So my friend is right, my lord, that it had come from the court if we could work out some sort of an amicable settlement, since this was his terminal benefits. On sometime in August 23, they supplied us a copy of the proposal. I've sent it to the department, but we haven't heard from the department as it. Because for this, the board will have to convene. The board of directors.
What is the settlement?
This is something which came from the court, my lords. Whether it was, we were in a position to try and work out some sort of an amicable settlement. This is during the course of the hearing, on which day they withdrew the miscellaneous application for amending their prayer.
That has been withdrawn.
Withdrawn.
Oh, please see, they take the amendment prayer.
So that is Miss Case 181.
Yes. I'll dismiss the petition. No case. Come.
Your Lordship, I'll just pray. Let the matter come up next week, Your Lordship. Let the matter come up next week, Your Lordship.
Matter? Not required, brother. Not required.
But Your Lordship, till now we are still waiting the outcome of the settlement, Your Lordship. That is why, Your Lordship.
Which one? See, you cannot even file another petition to amend the prayer because you have not sought the relief of the court. Withdrawn. You should have done.
Your Worship, at least let it come on Monday, Your Worship, maybe tomorrow.
Not required. If you have a good case, don't worry. Even if the cat on the wall case also, I'll try to give some relief. Come. The present writ petition has been filed. Challenging the order dated so and so and so and so. Stop. A reading of the prayer will make it very clear. The petitioner has challenged only the order, or only the communication asking the petitioner to submit an explanation. After the show cause notice, dated so and so, the petitioner has participated in the inquiry and final order dated 28/2015 was passed, withholding, correct?
Gotcha.
Withholding the gratuity amount. Full stop. Though the petitioner has challenged the communication dated dash and dash, the petitioner has approached this court by way of WP number 3301. What is the number, earlier number? 33?
That's 330/2012.
330 of 2015, challenging the
That's 2012.
12, challenging the impugned order dated so and so, and that has attained finality. The petitioner has once again challenged this said order before this court. As the finality has attained, insofar as the first impugned order is concerned, the question of adjudicating the same does not arise. To stop. The petitioner has rightly filed a petition to amend the prayer so that the entire proceeding can be set at naught and the terminal benefits may be extended to the petitioner, which was, and the same was numbered as miscellaneous petition 181 of 2022. For the best reasons known to the petitioner, the same was withdrawn. It's up. Today, when the matter is taken up for hearing, though the petitioner sought time to Monday, having gone through the papers, the petitioner will not be entitled to any relief as the show cause notice dated so and so has culminated into withdrawal of gratuity, non-grant of gratuity, and that has attained finality. The petitioner cannot file another application to amend the prayer as he has not sought any liberty to file a fresh one again. Since the petitioner has approached the court challenging the show cause notice, this court is not inclined to grant any relief and the writ petition stands dismissed, no cause. Since you have kept the Gratuity Act, somebody has kept Gratuity Act, advocate for the petitioner. So I was under the impression, under 4(6), you are trying to deprive him the gratuity.
No.
And then you have to conduct an inquiry, all those things will be there. Yes.
Item 34.
My Lord, I pray that the matter may be taken on 6th, my Lord.
You take time, it's not about today. All matters are posted only for fixing a date.
My Lord.
Is there anything there? What is the matter about?
Matter is, my Lord, the petitioner was serving in Assam Rifle, my Lord.
Teacher?
No, my Lord. As a general duty, my Lord. And thereafter he went on deputation to the National Police Academy at Hyderabad. From there, he sought an extension of tenure, my Lord. Even the academy has also sent a proposal for extension. but the respondent authority denies that, my lord. So, in the meantime, my lord, the respondent has not allowed the petitioner to rejoin, and the academy has not issued any movement order to enable him to repatriate to the concerned unit, my lord. So here the petitioner is challenging that the respondent be directed to reinstate or allow him to join the service.
Well, he went on deputation, my lord.
He went on deputation.
Deputation to National Police Academy, Hyderabad. And after that, he wanted to continue there only at any cost, my lord. Because we, as a parent department, my lord, we told him that your deputation period is over, you have to come back. He is writing later, he filed cases before the...
So, no interest to join?
No interest to join, my lord. So, because he did not come back, we have dismissed him from service, my lord.
Dismissed from service? After conducting inquiry?
No, man.
Because non-reporting for duty, my lord. We waited for some time and then we passed an order, my lord.
Yes. When do you want?
6th, man.
Next week. I think you are appearing on particular day. When is it? One of your cases posted sometime.
That was
5th.
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 Item 35.
What is that?
35. Yes.
But in this case, my lord, the petitioner was recruited, my lord, as a soldier in Assam Rifles, and then there is a training, my lord, of about 1.5 years. During the training period, he was diagnosed with TB, my lord. And the medical board of the Assam Rifles found him to unfit to continue in service, my lord. And so he was discharged on medical grounds in the year 2005, my lord.
2005?
In 2018, he filed the present petition, my lord.
After 13 years?
After 13 years, my lord.
Where is he? More representation for the petitioner post for dismissal on Friday.
This Friday.
Item 37.
There are a number of judgments,
my lord,
on the ground of
no relief can be granted now, my lord. After is about 19
latches, there are a number of judgments.
My lord. In fact, we have taken the specific plea, my lord.
Last year, I think I have returned about half a dozen judgments sitting in Madras High Court. Yeah. Where Krishna Kumar Arva has also been confirmed.
I'll try to look at the judgment.
Half a dozen orders of mine is there.
My lord.
Yes.
Lord, the petitioner, the prey is very limited, my lord, as far as this matter is concerned. But the issue is, my lord, the petitioner was working as work charge junior engineer, my lord, in the electricity department, my lord, board, 2007, my lord. Now, 2015, my lord, an exam was being conducted for the various work charge junior engineers, my lord, to regularize the service. Now, I was not permitted, my lord, to take part in the exam, saying that my degree, which I have submitted during my appointment, are not authentic, my lord. Thereafter, my lord, within a month, I was terminated. So, therefore, my lord, my
termination.
Yes, ma'am. Therefore, my termination is punitive.
Not regularization.
Yes, my lord. Punitive and also stigmatic, my lord.
Item number 30?
37.
One minute. Not regularization.
Yes, Lord. In fact, for the other employees, other work charge employees, they were given an opportunity to appear an exam for regularization, my lord. I was not permitted, saying my documents were not authentic, my certificates, my lord. I therefore, my lord, just allow me a little bit more, my lord.
You're ready?
I'll just explain, my lord. Ultimately, the only limited prayer I'm asking for is, my lord, compensation for my wrongful termination, my lord, because the termination itself was punitive and also stigmatic, my lord.
Tortious liability is not available.
My lord, I leave that to your lordships, but this is my prayer, my lord, because in 2018, I have now, my lord, obtained some other employment, my lord. So therefore, for the period between 2015 and 18,
3 years.
Yes, my lord.
And my lord may have this matter on Friday, my lord, or tomorrow, my lord.
During the course of these proceedings, my lord, the matter was sent to Lok Adalat. An inquiry was made by them regarding my degrees, and they were found to be genuine, my lord. That is the issue, my lord. In fact, an affidavit, additional affidavit has been filed, my lord, by them, in which we
start... Will they pay him some arrears or back wages, 20% or 30%, so that we can give a quietness to the matter?
My lord, yes.
My lord, that...
For 3 years, not for the entire period.
My lord, that was put up, my lord. An affidavit was also filed, which the corporation has rejected.
So we'll call the matter on Monday.
My lord, Monday.
You ascertain. He also says he has taken up employment. He's not interested in employment.
That's for your lordship, my lord.
What is the amount that can be given? Quantified?
That has already been, proposal was already given by the petitioner to us, my lord.
Well, and the
court has also looked into
What is making some suggestion?
My lord.
You pay 25 or 30%.
My lord,
from your employer.
we have this matter on Monday, my lord. We will argue this matter.
Madam?
On Monday, my lord.
Monday?
Monday.
You ascertain. You can say that the suggestion has been put forth by the court as to whether 30% of the arrears of wages for a period of 3 years, from 2015 to 18, can be paid or not. See, you are buying peace.
My lord.
Is it not?
Monday, my lord. Deep.
Monday.
Item 38.
See, inside the case, it's mentioned as, the docket is mentioned as 345. Inside is mentioned as 245. I got confused. You open the page, first page. Say the previous case. First page.
Yeah, from the council service.
Something. No, not you. Somebody has done it. Oh. Yes.
My lord, here the petitioner is seeking for the non-grant of ACP and MSCP.
I should carry a progression.
My lord.
Yes. What do you want?
It can be on 18th, my lord.
18th. The request of both parties post on 18th.
Item 39.
See, I request the bar to be ready in the next date of hearing. Today, the matter is posted only for fixing a date. We'll
be ready.
So that I want to finish up to 2022 before I leave.
My lord.
Now I posted it up to 2020. Some of the matters are parted before the other single judges. Some are before Justice Bhattacharya, some are before Justice Dingdog and before Justice thank you.
Yes.
So I don't want to withdraw that. So now I listed about 46 cases.
It can be disposed on within, by 18th, I think, till 18th you have fixed the matters now.
Yes.
Please, Your Lordship. My Lord, this matter relates to the appointment on compassionate ground. And the
matter
relates to the appointment on compassionate ground, my Lord.
Oh.
And the petitioner, my Lord, was appointed on compassionate ground 1994. Up till now, Lordship, she has not been promoted. Neither SP has been granted to her, Lordship. That is.
She has been appointed or not appointed?
Appointed.
Appointed. She has not been promoted.
No, Lordship.
Well, here the petitioner is questioning the seniority, my lord.
Seniority?
Yes, my lord. This is questioning the seniority in her service, my lord.
Seniority, apart from seniority, Lordship, promotion and ACP also has not
Once
been
the
granted.
seniority comes, everything will come.
That's
Whether we are entitled to that or not, we have to see.
true.
You are a compassionate appointee.
Yes, Lordship.
So, your father died, mother died, husband died, who died?
Mother died.
Mother died.
Yes, Lordship.
So, mother, she was in employment, so you got compassionate appointment.
Right, Lordship.
The class 3 or class 4 post?
Class 3 LDA, Lordship.
As?
Lower divisional.
He was appointed as LDA, my lord.
LDA.
LDA, yes. Then how are you entitled to promotion? On what basis you are seeking for promotion? Seniority. What are the grounds?
Lordship, since he has been appointed, and then other employees on the same ground, on compassionate ground, Lordship, they have superseded me, and then even seniority, they are, those who have been appointed after me, Lordship, they have been,
My lord, although she is challenging the seniority, my lord. However, my lord, the persons, in case, my lord, the event, her position changes, my lord, it is likely to affect the other parties as well, my lord. So, however, they are not a party to this writ petition, my lord.
They have not been made as a
They have
party.
not been arrayed a party in this writ.
They have not been made party because those employees have been appointed after I filed this writ petition, Lordship. After I filed this writ petition, then only they have been promoted. They have superseded
That
me.
is right, that once the seniority is going to be altered,
My lord.
they will be affected. Then there will be, we will be opening Pandora box. Several persons will approach this court. Should we not make others a party here before this court to enable them to have a chance to say whether you have got a right or not? And what is your right to get promotion? What is your right to get the seniority? That is the rule.
Lordship, since he has been appointed before them, and the other employees have been.
You have been appointed on compassionate ground. You are asking for seniority and promotion.
Lordship.
When you want a seniority and promotion, you must show the rules. You say some of them, some of persons have superseded you, or some of them have appointed after you.
Appointed after me, Lordship.
After you.
And then superseded me also. Appointed after me, and then even superseded me also.
Or that is after appointed. We do not know under what capacity they have done it. Should we not make them a party here?
Yes. They have to be a party.
On the ground of non-joint of party, we have to dismiss the writ petition. We'll dismiss it.
Lordship, because they have after I filed this petition, Lordship. After I filed this petition, then Lordship, they have been promoted and superseded me. Lordship, that's how.
Correct, sir. You are entitled to amend the prayer, which you have not done. Do you mean to say that once the prayer is filed, you cannot amend the prayer? You are entitled to amend the prayer. Suppose new facts are brought to your attention. Are you not entitled to file an original affidavit?
I will not. Lordship.
Similarly, you should have brought them. If you don't have the details, you should have asked them to furnish a list of names.
Lordship, I'll do
Is there any
whatever.
provision in the rules? There in the Madhya rule, there is a provision saying that the representative capacity, a person can be added as a respondent. If there are no 100 respondents, it is not necessary that 100 should be made as a part.
Hello.
The representative capacity is there under Rule 2A of the appellate side rules.
That
To make the respondents of the party. Rule 2B is for the petitioners joined together. Is there any provisions like this here?
High Court rules, of course, I do not have it at the moment.
On the
I'll check it up.
Meghalaya High Court rules?
My lord, I'll check it up.
You know case?
Lordship, I'll
What's your age now?
It's around 45.
45.
45, 46.
Where is your prayer?
Sorry, Lordship, I'm not really on the next day, Lordship.
Sir?
On the next day, Lordship.
Sir, you've been arguing for 15 minutes and now you are saying that you want the next date of hearing, next hearing. Srimati Degrees,
Lordship.
daughter of Srimati Basaya
Yamoj.
Where is your prayer, sir? Where is the prayer, the writ petition?
Lordship, I'm not in position.
Ready?
The prayer is at page 8, my lord.
I don't have my brief, Lordship.
When did you join?
1994, Lordship.
So from date of joining only, the seniority will be coming to force. How can you say date of approval?
Approval was, I don't have.
It must be approval was much earlier.
Approval was
92, 93.
2016, Lordship.
Approval was in 2016, my lord.
After a gap of many years.
So they have taken your service from the day 2016 only, not
Yes.
from 1994.
Yes, Lordship.
Yes.
How can you do that?
My lord, here the compassionate appointment also, my lord, it is not as per the scheme, my lord.
Huh?
Not as per the scheme and the guidelines. There is certain procedure which is to be followed, my lord. Vis-a-vis the other candidates, my lord, they have all been appointed in after
See,
following
once
the
a person is appointed,
my lord.
it's not a question of compassionate appointment or regular appointment or backdoor appointment. Appointment is once it's regular, that's all.
But it's not.
As long as it is set aside.
My lord,
by the
our
court.
stand is that, my lord, it's not a regular appointment.
Sir?
And my lord, this appointment was not a regular appointment, my lord. It was.
So once they enter the service, they deemed to be a regular appointee.
No, my lord. Because even in compassionate appointment, my lord, there is a certain procedure which is to be followed, my lord.
What is the procedure?
My lord, the procedure is laid down, my lord.
So compassionate appointment for the purpose of appointment alone can be taken. You can't say the entire service, they have a separate set of seniority list. They mean that they have a separate set of seniority list. Then what is the ratio given to the regular employee and the compassionate appointee?
But our stand is that, my lord, her seniority will be counted from the date of her approval, my lord, in the service.
Approval, approval, my lord. It was done in 2016.
Wait. It's not correct.
That is our stand, my lord.
Cannot be. You have to take into account from 1994. He is not able to put forth this case.
But, my lord, her service is regularized with effect from that date, my lord, in the year 2016.
See,
my lord, what the scheme, my lord, what the scheme lays down, my lord. My lord, of course, I have the scheme, my lord. The scheme, if I'm allowed to read.
Give the one day. I don't think you have a case. I don't think you have a case.
My lord, if that be so, my lord, ultimately the seniority will be affected, my lord. Even because, my lord, the petitioner is at the bottom of the seniority list, my lord. So even if that be so, my lord, the seniority of the other candidates will also stand affected, my lord.
That is right. That is right. We will say that the appointment from 1994 will have to be taken. You have to redraw the seniority, call for the objection from the other candidates, then fix the seniority accordingly. Now, we are not going to say, I am not going to say that fix the seniority, restore it. He is entered with due seniority and the entire period from 1994 will have to be taken into account. Redraw the seniority and give him a place in appropriate place, that is all. Give him all the consequential benefits. That has got to be given. Once the person enters the service.
But, my lord, the manner in which the person has entered the service, my lord. The appointment was not regular appointment, my lord.
That is right, sir.
My lord.
If it is an irregular appointment, a regular appointment, compassionate appointment, or backdoor appointment, as long as that is set aside. When they are in employment, the same stream will have to be followed. You can't do, if your stand is accepted, then compassionate appointment, people must have a separate seniority list.
Yes, my lord.
If you do that, then there should be a ratio for when they become promotion. Do you have a ratio to that? Definitely no. To my knowledge, it will not be so. How can they say that 1:2 ratio can be fixed? One from compassionate appointment, 2 from regular appointment.
My lord, the others are also, my lord, in terms of seniority, my lord, even the other appointees are all compassionate appointees, my lord.
That is different. That is different.
In those cases, my lord, all the due provisions of law have been followed, my lord. The procedure has been followed, my lord.
Once it is approved, the approval will take effect from the date of appointment. Unless the rules are there contrary to that. Anyway, we'll call the matter on Monday. You get it, come ready. I will also go through the paper.
My lord, next week, any other date, my lord? Of course,
Tuesday.
My lord, 6, there are a lot of matters listed, my lord.
Where?
Before this honorable court, my lord.
Doesn't matter. I am going to read, you are going to read. That's it.
My lord, can it be on 7th or 8th, my lord?
7th and 8th is not possible. I don't, 12th.
My lord.
12th. So this is the only point.
My lord.
Item 40.
So with the limited knowledge of service law, I can say that there cannot be any two different service conditions for compassionate appointment and regular appointment. There cannot be.
My lord.
Yes.
My lord, both these writ petitions are related to pay as per the 5th Pay Commission. The 5th Pay Commission had made certain recommendations as far as rationalization of ranks in Assam Rifles at par with other paramilitary forces are concerned. In this case, my lord, this is not pending because a similar issue was pending before the division bench and we had to wait. And now the division bench order has been taken to the apex court by the Union of India. The SLP is pending, although there is no stay, my lord. The last few orders of this court say that we are awaiting probably some sort of a order from the Supreme Court to come, my lord.
Oh, the matter is pending before the Supreme Court. Identical issue.
My humble submission, my lord, so kindly seize the prayer, my lord.
No, see, he has submitted connected matters are pending before the apex court yet to be disposed of. This has been recorded as early as on 14/2/2024. I think Justice Bhattacharya has recorded it.
My lord.
But my lord, it appears, my lord, that...
And the learned judge also stated post after 4 weeks. They wrongly posted today. 4 weeks means it will come only in the month of March, 10th or 11th of March.
My lord, but the submission that similar matter is pending before Supreme Court.
That's what he also says.
My lord, kindly see the prayer, my lord, at page 28, my lord, in the present writ petition, my lord. Page 28, my lord. The second prayer, prayer number 2.
Writ of management directing authority to grant repetition classification of prey appointments also. Force pay and other granted similarly paid. Settle paramilitary forces of Union Ministry of Affairs. Yes, sir.
My lord, what my friend is referring to, those are different matters, my lord. Here he is asking for promotion, my lord, to a certain grade.
But last time both of you made representation that was recorded.
My lord,
according to a different case.
According
to your friend Mr. Kumar, he says it's a different case.
My lord, there is a slip.
Mr. Pathak.
My lord.
Yes, Mr. Pathak, he says it's a different case.
The way I am putting it is that the 5th Pay Commission have made a recommendation that you have to class-wise categorize and give rank and pay accordingly. Now, for us, my lord, we are stuck as hawaldars. Now my posts in class 2 and class 1 are being presently filled up by the army people. If Fifth Pay Commission recommendation is implemented, my lord, this class 2 and class 1 post of Night Subedar and warrant officer
whether it is connected to the Supreme Court matter or not.
And it is connected because otherwise the Fifth Pay Commission benefits have not been granted to us. That is also one of our prayers.
Take a chance, sir. Well, the matter is listed wrongly. On 14 to 2024, a single judge of this court has posted the matter. Direct the registry to list the matter after 4 weeks. 14 to 4 weeks signing over, sir.
As per CIS probably
13th Norma.
12th, some matters are fixed. It can be on 12th, 12th or 18th. Either 12th or 18th.
12th.
12th will be almost 4 weeks.
For CIS, my lord, it was earlier fixed on 18th.
Sir?
The CIS, my lord, court information system shows it is fixed on 18th.
We'll see, we'll call the matter on that day. We'll go to the paper. On 12th of 13th of March.
Give your life.
Item 41.
So, Lordship, the petitioners are the stenographers working in Assam Rifle. By this writ petition, they are seeking parity with the stenographers working in the other paramilitary forces in terms of rank, structure, and pay, Lordship. Lordship, I'm praying if this matter may come up on 18, Lordship.
You want the parity on par with?
Par with other paramilitary forces. That is the CISF, the BSF.
You're stenographers.
I am the stenographers, Lordship, working in Assam Rifle.
So other stenographers are also getting the same belief.
Lordship.
What do you say, sir?
They are not entitled, you see.
They are not?
They are not entitled. They are, as per recruitment rule, they are not entitled.
Why?
Because recruitment rule is different, you see.
Huh?
Different recruitment rule for that different.
Different?
Different recruitment rule. Other CP they are having.
Stenograph stroke are going to be one and the same. He will be taking the same way, he will be taking the same way.
Recruitment rule is different, you see.
If he is asking for parity on par with other paramilitary forces. You take the judgment of Supreme Court in 1959. AR 1959 Supreme Court. Please note down. AIR 1959 Supreme Court. Lipton, India. Judgment. Similar argument was taken there. The stenography and the typist and other way. Some of them were oil company, some of them were different companies, textiles, etc. The Supreme Court has held that the job performed by the stenographers are one and the same. Do you have a AR here? Get to AR 1959. Lipton, India. Though the case arose from the Industrial Tribunal and went to the Supreme Court, in the similar paragraph, the relevant paragraph starts at on the right hand side of the judgment and relevant portion is extracted on the left hand side.
Here in this
I'll
case,
give you the judgment with the page also.
Here in this case, you will see it is prop up all these litigations here. In this case, you will see petitioner is here. They are asking the pay parity due to this Fifth Pay Commission. There was some changes in the cadre, and subsequently recruitment was prepared, and based on the recruitment they have appointed. They are asking the benefit earlier it had.
We'll see that whether they are entitled to or not. This is the judgment. When they are discharged the same work, they are entitled to the same benefit. The same area. If it's a different area, it's a different. So different place, you will be having different pay depending upon the city, region. For example, my PA who's come from Chennai, he will be having higher amount, higher pay scale compared to Meghalaya. That is different. Here he is asking in the same region. How can I differentiate?
Because other CPS are there different, intermediate room different, and appointment procedure is different.
Get ready with the matter. We'll finish the matter on Tuesday.
Lordship, I'm bring on 18, Your Lordship.
Why is that?
18, Your Lordship. Because
the auspicious day.
Lordship, there's another matter which is fixed on 18. The arguing counsel is from out of station.
Sir,
So it is 18.
don't expect the counsel to come, sir. It's an opportunity for you to argue.
Lordship, indeed.
So I'm asking question, I'm giving you the answer. Question paper has already leaked out. 1959. GHIJ. Completely what he done. Here, 1959 Supreme Court 676. Paragraph number 26. Paragraph 26, the left hand starts it on the right hand side, ends at bottom at 688. It is not being disputed before us. The existing wage of a Delhi employee is far below the living wage. We need not concern about the living wage, minimum wage, etc. The first question is whether there is any reliable evidence to show that the comparable industries in the same region, as the same region, the wages are higher and therefore the wage structure should be required to be revised. On behalf of the union, evidence was let in of the employees in Delhi office, number of industrial undertakings such as Standard Vacuum Oil, Thomas Cook, Overseas, Burma Shell, Liver Brothers, associated companies. On behalf of the management, it was contended that none of the above are comparable industries. Some are oil companies, some are engineering concern, some are manufacturing concern. Pointed out that insofar as drivers, sweepers, peons, clerks, godown keepers, typists, stenographers, now we are asking for stenographer, and the like are concerned, and these form part of bulk of the employees. The nature of work is important. This side is important. Nature of work is about the same in all the efforts in the industry, and therefore there was a basis for comparison on which the tribunal below could proceed. We are of the view that it is impossible to say that in this case there was no evidence on which the tribunal could proceed to revise the wages so and so. To revise the wages. So I pose the question, I have given you the answer. What is it you want? You don't want any relief?
Lordship.
You want only adjournment?
No, Lordship. I'm a bit handicapped, Lordship, because I'm not the counsel. On 18, Your Lordship.
Yes.
Maybe it is possible.
When do you want?
18, Your Lordship.
Sir, we will pass orders day after tomorrow. Tomorrow itself we can pass orders. We are ready. Very simple case.
Next week, Lordship. Next week. Lordship.
Tomorrow. What is this, sir? Can't stand like a pillar. Yes. See, I'm telling you, all of you must read books. It's very important. Very, very important. Otherwise, very difficult. Every day we are in the learning process. In one of the speeches, on the retirement day, I also said, my father said, when I want to take up the profession, he said, your student life begins now, he said. Law college and all, it's only for the purpose of getting qualification and degree. And our life starts only after becoming a lawyer. You read, I still remember the words of Justice Chandukar and Justice Srinivasan, they were in the first bench. One of my junior was arguing, Purnima, she was arguing. And my senior said, you go and stand next to her. A very good case for her. And she studied in a convent. At least I studied in Tamil medium. So I don't know English. My English is very poor. And the Chief Justice posed the question, what do you say about the case? She said, I have a cakewalk case. Chief Justice said, you can't say like that. Do you have any authorities? She was not having any authority. I was telling her, show this, give this citation, give this citation. Because of the question posed by the Chief Justice, she was not able to listen to me at all. Then Justice Chandukar said, books, judgments are like insurance policies. It will come to aid when you are in struggle before a court. That is why I am saying that please read the judgments. It will be helpful to you. Yes. Pleasure. Next. That's all. Date. They want some. 21 next week. Tuesday, Wednesday.
Lordship, I was praying on 18, but Lordship's convenient.
You don't want to use the opportunity. What to do? See, don't expect the seniors counsel. Don't expect the counsel. You read. You tell the senior, these are the points. Then he will be convinced to I'll permit you to argue.
Lordship. Next week, Lordship.
Who's on? 6th.
6th, Lordship.
You're on with the matter. Sir, you also please chart out. What are the points? See, merely because I've cited this judgment, I mean given you the judgment doesn't mean that I can follow. If you are able to distinguish the judgment, you can distinguish it. Yes.
Item 42.
Yes.
Please proceed. This is the petitioner here for 2 grievances. He was terminated, he was suspended without issuing any show cause notice, Your Lordship. And moreover, till date, he was suspended in the year of 2017, but till now there is no disciplinary proceeding against the petitioner. And the petitioner was promoted to the enforcement director where there is no force created.
Is a case of suspension?
It's case of suspension, Lordship. Case of suspension at the same time.
How long have you been on the suspension?
Since I have been suspended since from 2015, Lordship.
You've been in suspension last 10 years?
Yes, Lordship. Lordship. Till now there is no disciplinary, interestingly, no disciplinary proceeding against me.
Are you getting subsistence allowance?
They have paid some, but till now, for another 7 years, they have not paid this.
7 years they have not paid?
They have not paid. To some extent, they have paid.
What is this, madam? Who is the officer?
Chief Executive Officer, Your Honor.
Government also is a party, Lordship. Here, this is the municipal, Lordship. We have make a party to the director of.
How can you place a person under suspension and not paying subsistence allowance?
No, Your Lordship.
Who is responsible to pay subsistence allowance?
According to the Annexure 1, Your Lordship, in our affidavit, we have mentioned, Your Lordship, that we have paid the amount.
That is the salary for all this one. Payment of salary and suspension is different. What my learned friend is referring is that they have paid some salary to all the employment. I also one of them, the employee. That is what she is.
So you said that from 2017, the no subsistence allowance have been paid. Correct? You have been paid, suspended in 2015, 31st August 2015.
Lordship. Devise the impugned suspension order, Lordship. It is in that.
But how can you pay, keep an employee without paying subsistence allowance?
No, Your Lordship. If you can check in Annexure 16, Your Lordship. Annexure 16.
16.
In our affidavit, Your Lordship. Page 56, Your
1
Lordship.
minute. Yeah. Misuse of funds.
No, in our affidavit, Your Lordship, which was
Placed under suspension, immediate effect. Will be paid subsistence allowance, day and salary as admissible.
No, Your Lordship, in our affidavit, which we filed on 18 August 2022, Your Lordship.
Which one? Yes.
Affidavit, which we filed, Your Lordship.
Affidavit?
Yes, Your Lordship.
Yes.
Page 56, Your Lordship.
Huh?
Page 56.
56.
Yes, Your Lordship.
So this is the order. Affidavit of opposition. Yes.
We have paid, Your Lordship, for the subsistence allowance on 14 December 2021 also, Your Lordship.
From 2021 till now, they have not.
But how can you place a person under suspension, madam, without paying subsistence allowance? Where have you paid? Where is the proof that you have paid? Who is the person who was sworn in the affidavit?
For the last 2 years.
See, the cost title is not full. See, I am not in a position to understand who is the fifth respondent, who is the fourth respondent, who is the fifth respondent.
Lordship, it's referring from the affidavit of an opposition. I mean, for the petitioner, Lordship, it is there in the.
See, the order copy also doesn't contain full cost title. Your writ petition doesn't contain full cost title. How can you find out?
Page 3, Lordship.
Huh?
Page 3.
Page?
Page 3 of my writ petition.
Page 3 of your?
Petition, writ petition. She's referring to the affidavit in opposition.
The municipal board.
Municipal board, Lordship.
She is the fifth respondent.
She is for the private respondent.
Is the?
You have private respondent?
No, for 3 and 4.
3 and 4. 3 and 4. She is for the 3 and 4, the chairman of Bakmara Municipal Board and chief executive officer, Bakmara Municipal Board.
From where they are getting the salary? Chairman, the chief executive officer being paid by who? Who is paying him the money? Monthly wages, monthly salary. He's doing free of charge?
No, Your Lordship.
Service?
No, Your Lordship.
He's also getting a remuneration, is it not?
Yes, Your Lordship.
So he'll pass orders.
No, Your Lordship.
Stopping payment of wages to that person official.
No,
Let him not draw salary.
It's not like that, Your Lordship. Your Lordship, if in that case, then let it come next week, Your Lordship. because the conducting counsel.
How can you see? It's not at all fair. Not at all fair.
We have
Placing a person under suspension for 10 years.
We have given him the show cause notice also, Your Lordship.
Well, that is different. Even if you dismiss it, we are not concerned about it.
Because as per the FIR, we have been enclosed here, he was misuse of the funds also, Your Lordship.
That FIR, there are two FIR. I also filed the FIR against them.
You have stated that you will pay the subsistence allowance in accordance with the rules.
Yes, Your
What are the rules? 50% subsistence allowance? Thereafter, after 150, 180 days, sorry, it's a government service, you know?
No, sir.
After 6 months, you must be paying 78%. Is it not? Without extracting work, a person is getting 75% of the wages, which amounts to 100% because he is not going to travel, spend anywhere. 75% is equal to 100%. Because there is no transportation, he need not come to the office, he need not spend money for coffee, tiffin, etc. Supreme Court has come down heavily in two matters. Even a person facing a criminal case, if the charge sheet or not filed within a period of 1 year, they said you place him in a non-sensitive post. That is a judgment. There are two judgments of the Supreme Court. Two judgments. You see Ajay Kumar Chaudhary's case. On return of the judgment is there. See, you are making a Chief Justice will be a lecturer now, taking law college. I may be a chancellor of the law university, but doesn't mean that from sitting here I can conduct classes. Then I have to keep a blackboard here. Please come prepared.
Yes,
see, otherwise the next hearing, the officials will not drop pay. We'll stop that. We'll stop payment. They will realize. Then they will know. Not even a fine will be paid to the government officials. Yes. Yes. Date. When do you want? Next week she wants on next week. Post on 5th. 5th or 6th?
6.
6th.
6.
Next hearing, you bring a demand draft for the subsistence allowance due to him. Bring that and pay to him.
Then if you kindly fix on 13.
Who is the official concerned, madam? Who is the official concerned who is responsible to disburse payment of subsistence allowance?
Chairman.
Who is the official?
Chairman, Your Lordship.
You don't know.
Chairman of Municipal Board.
Ask him to appear through video conferencing, the next hearing. Ask the official to appear through video conferencing. Ask him to appear. It is represented by the counsel appearing for the petitioner. The subsistence allowance for more than 5 years have not been paid, and that the respondent have not initiated departmental action. The counsel for the respondent submitted that a portion of the subsistence allowance have been paid, and she is not aware as to whether periodically subsistence allowance is extended to the petitioner. She sought time by a week in order to assist the court. We expect the authority who is responsible for disbursement of subsistence allowance and conduction of department query to appear through video conferencing in the next date of hearing. Let them appear. If they don't appear, then we'll ask them to appear in person.
List number 13, Your Lordship.
Ask them to appear. If one case will stop payment, then everyone will follow.
I'm be Your Lordship, let this matter be fixed on 13th.
Madam?
Let this matter be fixed on 13th, Your Lordship.
Want it on 13th?
Yes, Your Lordship.
13th.
Much obliged, Your Lordship.
Item 43.
Much obliged, Lordship.
40? Last case. Yes.
Lordship, I'm praying that this matter may come up on the 6th of March.
8th of March.
6th, Your Lordship.
6th of March. This is with regard to reservation.
Your Lordship. Lordship, here we are challenging the selection process. Your Lordship. The advertisement is for the post of LDA of 32 posts. After appointment, there are 59 posts which are being
file your objections.
My Lord, I have filed.
You are also ready.
My Lord, I am ready.
Post on 21, 18th.
6th, 8th, Your Lordship.
18th.
18th.
That's good. 8th. 8th or early.
13, Your Lordship.
18th.
Deeply obliged.
Deeply obliged.
That's all. Oh.